Médias sur Africa. L'Afrique parle. 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 Médias sur Africa. L'Afrique parle.
Mesak Kamajau et al. Versus Emmanuel Mbanku or Mbanke et al. Good morning, Council.
Good morning.
I hope I didn't do too bad a job with the pronunciation. So, whenever you're ready, take your time.
Thank you, Your Honor. Good morning, Your Honor, and may I please to court. My name is Gertrude Ngamga Kamshon on behalf of the appellant, Ms. Kemaju, Aline Kemaju, and Active Solidarity or Solidarity Agissante, aka Sagi. This matter is on the direct appeal from a default judgment.
No, it isn't. I mean, it's not. You had a trial, right? This was not, there was an answer, there was discovery, there were opportunities for discovery, there was a trial. It's not a default judgment.
Okay, Your Honor.
Is this a default judgment or a not showing up at trial judgment?
Judgment by default. The appellant was, they were not.
Default judgment is a thing, right? Default judgment happens when there's no answer filed.
Sure.
And then there's a request to the clerk for an order of default, and then 30 days passes with no motion to vacate the default, and then it turns into a default judgment, and you have to deal with damages. That's not what happened here, right? There was this case has a much more fulsome procedural history.
Okay, Your Honor.
I mean, and I think that colors some of the arguments that you've tried to make here. I mean, if this truly was a default judgment, there might be some questions about what could or couldn't have been handled during a damages trial or something like that. But that's not what happened here, is it?
No, Your Honor.
Okay.
Okay. Yeah, we have raised several issues, but one of the biggest issues was insufficient evidence or lack of evidence. And believe that the trial court abused its discretion in that matter. We talking the entire case, the appellate entire case is based on allegation without really.
Well, they put it. I mean, they had witness testimony at trial that was sworn and documents that were admitted and accepted and effectively undisputed.
Yes, Your Honor, but those documents were fabricated. I feel.
You say that, and I understand that's your position, but there was no evidence before the circuit court of that, right? I mean, these documents were admitted at trial.
And that's true. They were admitted because
there was nobody there to object
to
right.
this evidence,
right?
But if you carefully review the evidence, you could tell that evidence is kind of like altered or fabricated.
Why is that an exercise that we should engage in now?
Excuse me.
Why is that an exercise that we should engage in now on appeal?
Well, we're asking the court to remand it for retrial.
On what basis?
So we can determine.
On what basis could we order this case to be tried again?
Abuse of discretion.
In
of
what,
the trial court.
In what way? Well, how did the trial court abuse its discretion? And I guess in asking that question, there are a few different decisions you may be pointing to, right? I mean, we had, Judge McGuckian handled the trial, but there were decisions earlier by Judge Coliff, I think, and Judge Maloney. So when you say the court abused its discretion, help me understand which elements of its exercise of discretion you're pointing to.
Well, because what I'm saying, abuse of discretion, because the court didn't consider the certificate of incorporation that was filed with the answer, and the certificate of incorporation clearly shows that Appellant Mirza Kemaju is the founding member and the owner of Sagi and the sole directors. It was on the file, it's on the file. He answered, at least that evidence should have been considered. It was never considered.
Well, but an answer is not admissible. It's not admissible evidence. Answer is a set of counter allegations, right? They counter the allegations in the complaint. Just as the complaint isn't admissible evidence, the answer is not admissible evidence.
But the thing is, it was.
So are you saying that the trial court was obliged during the trial, when the appellants were not there, to on its own challenge the presentation that the plaintiffs were making with the counter allegations in the answer? The trial court was obliged, under pain of reversal, to take the documents that may have been referred to in the answer and cross-examine the witnesses itself.
Well, because the appellee testified that they registered the company, but they never provided the certificate of registration to the court. So if they have provided a registration, since they're alleged to have registered the company, the judge will have noted that on the certificate of incorporation, only Mirza Kemaju is listed as the owner and founding member of the of Sagi.
So wait, so you're saying, are you saying that the presentation that the plaintiffs, now the appellees, made at trial was not sufficient to sustain the finding?
That's correct, Your Honor.
Tell me how that's true. I'm not sure that's what you argued in here, but we'll go with that for now.
Well, the appellee testified that they registered the company. If they testified that they registered the company, they should at least provided the certificate of incorporation. It's a public record. It's not like if they don't have, it's a public record. They should have submitted that. Even when they file a complaint, they talk about it. When they never produce that during trial, they never produce that. We provided the certificate of incorporation, but they never ever once provided a certificate of incorporation to courts.
Was that document necessary to prove the causes of action that they alleged and sought to prove at trial?
That document was necessary to prove that they were founding member, because they're being alleged to be founding member of Sagi. But they were not.
Okay. So other than that one document not being produced, how did the trial court abuse its discretion?
Well, because they didn't produce that, I mean, because they didn't produce that document, the court wasn't able to make a decision accordingly. Yeah.
Okay.
And because we saying that the appellate weren't founding members, so they do like standing even to bring the lawsuit, because they were not founding members. They didn't prove that they were founding members because the document they provided were falsified. The bylaws, no adoption, there's no date of adoption there. There's no signatures of the so-called founding members. And you look at the and you look at the secretary incorporation, we have only 3 directors and only 1 founding members. And that document appears altered. And if you look at the first page of the bylaws that is submitted, the first page says they created the company in August 2009. In the Secretary Corporation, the company was registered September 2009. And that bylaws, the bylaws already noted the number, the registration number of the corporation. It was noted there already. So that's why we think that that document was fabricated. How did they create the company in August? They already have the registration number already listed on their bylaws. It doesn't make sense to us. And Sagi never had a bylaws, never ever. And if you look at the testimony of the corporate designee, Chanke, he did say Sagi, there were never bylaws. Sagi, Meza Kemaju, Appela Meza Kemaju, that was his staff. There were no, the only founding member was Meza Kemaju. Other the appellee, he doesn't know where they're coming from, talking about being founding members. So the whole issue resolved around founding members. Are they founding members or I don't know, founding members? They're not. They're not. So they brought the lawsuit, and we think that they lack standing because they're not founding members. And at the time they brought the lawsuit, they were not even regular members. They were expulsed in 2016, and the lawsuit was brought in 2020. Their lawsuit was brought. I mean, they counterclaim the lawsuit brought by Appel and Meza Kemaju. They counterclaim that was after 2016. And then they had a tolling agreement. They had the agreement that to toll the statute of limitation, and they brought the lawsuit. Meza never brought the lawsuit again, but they brought the lawsuit against Meza Kemaju. So at the time they brought the lawsuit, they were not even regular member. They were neither founding member nor regular members. So that's why we believe they lack standing to even bring the lawsuit before the court.
How do we get around the fact that the trial judge found differently?
Well, this is the thing. We think that even...
How is it that we could counter that finding now on the record we have before us?
That they lack standing.
I mean, we have findings of fact and conclusions of law to the contrary.
Well,
bumped up against the absence of a trial record on your side because no one was there. I'm just asking, how is it that we can counter that? Even if, let's say I believed everything you were saying was true, how on this record can we make those findings?
Well, of lack of standings? Well, like I explained earlier, I mean, the records, the records on file don't show the family members. Even the record that they provided is falsified.
Thank you.
And we believe it was so unfair because at the second, I believe, the first motion to dismiss, we brought the fact that they lack standing members, but the judge gave them a favor because he didn't know how to rule on standing. He gave them a favor and gave them an opportunity to refile it. That was really prejudicial to my client.
That was in the tolling agreement.
That was not on the tolling.
The tolling agreement included a right to file again, right? And then there was an argument about whether the new filing was filed too late, and then I think it was Judge McAuliffe did the math against both the time in the tolling agreement and the operation of Chief Judge Barbera's administrative orders from COVID and found that it was timely, right?
Right, I'm not arguing tolling here. I'm not arguing tolling. I'm just saying the first judge didn't even know how to rule on standing. And he said he's doing them a favor not to dismiss that. Another judge would not be lenient. So we feel like the appellant were prejudiced here.
Okay, you've got 6 minutes on your rebuttal argument.
I'm sorry. I'm out of time.
Yes, you're out of time now.
Sorry.
Thank
you. Good morning again, Your Honor. This appeal is what I would consider to be another attempt to prolong the litigation and rein the nonprofit. And one proof of that before this court is that the reply brief in this case was filed about 90 days after we filed our own brief, and just last week. That issue aside, it shows a pattern that is consistent with how the litigation has been handled over the years. We had the first case where the appellant filed, and after years of litigation, we reached a tolling agreement for purposes of having accounting done, and that agreement provide for the court to have to retain jurisdiction to continue with the proceedings. Then the appellees filed a pro se complaint and subsequently retained counsel. Initially, the complaint was they moved to dismiss, then they retained counsel. There was an amended complaint filed to clean up the issues, and there was another motion to dismiss filed. The motion was denied. Then we go to discovery. Counsel for the appellant propounded discovery, and we also propounded discovery, exchange, and eventually there was a 30B6 deposition, the corporate designee deposition taken of the appellant. They took time to designate a corporate designee, and there were exhibits exchanged and never objected to by the defense or by the appellant's counsel in those depositions. And eventually trial was scheduled. The first trial was in December, and the week before trial, we get a call that counsel was not going to be available, they need postponement. We opposed, the case was postponed nonetheless. And then comes a motion to withdraw from the appellant. And all this while there's a proper notice sent to the to the defendant themselves, the two defendants, that you don't have counsel, you need to hire counsel. They did nothing, and they knew the trial that was coming. On the 11th hour, they filed a motion to continue, which was never served on us. Meanwhile, we're preparing for trial. And we show up on the date of trial to learn there was a motion for postponement that was denied. The interpreters are present, everybody's prepared for trial. The trial goes forward, and the judge hears evidence. And the most salient evidence presented on that day was the actual corporate designee deposition transcript with the attached exhibits, exchange and discovery, sent by the defense. And then, after the trial court made the findings, the defendant hired a lawyer, they filed a notice of appeal, without knowing what the issues were. Before filing the notice of appeal, as a matter of right, I recognize they have 30 days.
You don't have to say anything about your issues in the notice itself.
That's correct.
I dare say people probably figure out their issues after they file the notice most of the time.
Right. So, and today the questions becomes, what are the issues being raised before this court? And I heard in argument earlier, the appellate counsel responding to your Honor's questions, there may be sufficiency of the evidence. And the burden of proof in a civil case is preponderance of the evidence, meaning even a single testimony that is admissible and accepted, it's enough for the plaintiff to meet the burden of proof if there's nothing else to counter the testimony.
Sure. I mean, but you could also have a case, even an uncontested case, where you don't put on enough to satisfy the elements of the claims you're making.
Right. And in this
Her argument, I think, is that the premise that your clients are the founding members or otherwise imbued with sufficient authority in the life of this nonprofit to raise these claims, as I understand her argument, is belied by just the articles of incorporation themselves, which were never admitted into evidence at trial. That's her argument. I haven't gone back to check whether that's true, but maybe you could respond to that.
Yes, Your Honor. So, and the question becomes, one of the claims in this case was whether the appellant, Ms. Akemaju, actually even have authority to dismiss the appellees in this case, our founding members. And the court said no. The bylaws which govern nonprofits were admitted into evidence, and I want to point the court to our brief here, page 21, and it cites not just the transcript at page, the electronic record is 152, and cite line 21 to 25 and line 1 to 12, where the court took time to review the actual bylaws and said there's nothing in the bylaws that gave the appellant the right to dismiss any member whatsoever. The appellees are members of the General Assembly, for the very least, setting aside the fact that they were founding members, or what we would call for in any nonprofit, member of the board of directors. In this case, he single-handedly decided that they were no longer member by passing the bylaws that he himself has given in discovery. And the same bylaw says, under the terms of the bylaws, and I quote, there were in fact members of what is called the General Assembly. Because this is what the court found, because the General Assembly shall be made of the founding members plus one delegates from each Sagi associations. There is nothing that anybody has shown to me that would say those members of the General Assembly can be expelled from the corporation. I don't see where there is any authority, and this is what the court highlighted. If it exists, it is not in any of the document that I have seen. So the three plaintiffs were clearly members of the General Assembly. So we believe that the evidence presented before the court were sufficient for the plaintiff to meet the burden of proof of the claim alleged in their complaint. there was some issue with, and I wasn't following correctly, the same thing that I couldn't follow in the brief with the article of incorporations, Your Honor, not having a name or somebody sign on the article of incorporation is not in and of itself a suggestion that the person is not part of the corporation. I think we can all, it's pretty clear, we can all form a corporation and have one person sign the name to incorporate, and then we have the bylaws that determine not only who are the members, how the board of directors can be organized, all of those things. So I don't believe that not having the article of incorporation here is in and of itself determinative of whether or not the plaintiff has met the burden of proof. But even that evidence, I believe, was also admitted at trial. I don't even believe that, I don't understand the argument in this case. I'm not really sure what to make of the issue being raised here. But
yeah, it sounds like what you're saying is there's no dispute about the contents of the, no dispute raised at trial about the contents of the articles and whether they matter, but that if you read and apply the bylaws, then your clients had the authority.
That's absolutely correct.
To bring the claims they did, and then you get into the questions that Judge McGuckian answered about what happened with the money and the different decisions that got made and whether the accounting happened or not.
That's absolutely correct, Your Honor. And I think if we have to take a step back and look at exactly the reason why the case was filed in the first place, is that this is a nonprofit that was set up for a very, very nice reason. Member of the same community, struggling abroad in this country, when somebody dies, they have difficulties returning the bodies in Cameroon. So they decided to come together and put a nonprofit. When somebody dies, they raise money across the United States, depending on how many members there are, and usually it may come out to $3 per person. And a body that would have been shipped back to Cameroon for about $20,000 from the family, it's now costing each person $3. Every time there is a death, money is raised, put together, ship the body. Very nice reason. This is a nonprofit. So how could a nonprofit operate without any oversight?
Oh, well, that happens all the time.
It
shouldn't, right? I mean, that's the whole point. It's supposed to operate for its intended nonprofit purposes, but we all know examples of nonprofits that go astray.
The founding member, the people that actually started doing the door-to-door of this organization, Patrick Zeno, Mezak Kemaju was part of them. We don't say he was never called in there. There were 6 other members, including the appellant. We're not challenging that he was not part of it. That has never been a claim made by the plaintiff. The claim made by the plaintiff was that he lacked the authority to single-handedly dismiss the remaining members of the board.
Right.
Without having been elected as president or director himself, there's nothing, not even in their own set of discovery, not even in the brief that counsel for the appellant submitted, there's no suggestion or no argument in there that he has the power to do so. So the question they also raise is whether the appellant or the appellees have standing to bring suits. They do have standing to bring suits as a member of the General Assembly themselves, but also as founding members, as the bylaws clearly says they have the right to do. I don't believe in this appeal that there's been any showing whatsoever of any reversible error, and I would ask the court, urge the court to dismiss this appeal and leave undisturbed the rulings of the trial court. There's been all sort of complaints about all sorts of the rulings made by all of the judges of the trial court, and the only person so far that's been correct, or in his view correct, is the appellant, and we will be asking the court to dismiss the appeal. Thank you.
Thank you.
Sorry, Your Honor. We just heard that the appellant submitted the ballots. We never submitted ballots. It's their ballots. And we're saying that the ballots were altered. Also, we think there was lack of evidence. Again, we come back to lack of evidence. They allege that Mr. Kemaju embezzled the funds. They never submitted any evidence of embezzlement. Never. They didn't tell the court how much he embezzled. They also say he failed to cooperate with the audit. They never submitted any evidence whatsoever. No testimonial evidence, no evidence, documentary evidence. So that's why we believe that the whole, the judgment was based purely on lack of evidence. And yeah, allegation without evidence. That's how we believe. And there were no General Assembly like here, the appellate claim. The bylaws, again, never existed. There were no bylaws in the so-called 6 family members. Appellant doesn't know them except for Emmanuel Banker, of course. The rest, Patrick Zuna and all that, no. They never, ever been even at the meetings of the regular meetings. They were just regular members. And we insist that the family members, they were just one family members, and that no family members. Sole owner was Mr. Kemaju, and they're saying that they didn't produce any meetings, for example, to say, well, they agreed to do this or to send Mr. Kemaju to register anything. There is no meetings. They just saying stuff without producing any document whatsoever to really call what they testifying about. And so we just want the court to remand it for retrial or reverse lower court decision. Let me see. In addition to all those, we have procedural errors here. Like the finding of facts never filed. Appellate counsel was repeatedly told to file and serve. They were never filed, and the judgment was entered. So we didn't even know what the finding of facts were, and it kind of prejudiced the appellant in that regard. And in addition to that, also we are issued with venue. With respect to venue, we believe that Montgomery.
About that, didn't your clients file the initial lawsuit in Montgomery County in the first place?
He did, but he was.
How is it that you can object to venue?
But he was the one filing against all the appellees.
Okay, but your argument is that venue is improper in Montgomery County.
That's correct.
But I don't know how you can argue that when your client filed the initial complaint in Montgomery County in the first place. I mean, never mind the fact that there were findings later that venue was appropriate. Forget that for that. It doesn't the fact that your client filed the initial lawsuit in Montgomery County in the first place solve the venue problem?
He did file.
So how can you object to venue in the related litigation that flowed from it?
No, Your Honor, this is two different lawsuits.
I know it is, but it's two different lawsuits, but they're two related lawsuits.
They're not. They're not related, Your Honor.
Related at all.
They're not related at all. They're two different lawsuits.
The tolling agreement comes out of the first lawsuit, and that tolling agreement is what gives rise to the second lawsuit. You're saying they're totally unrelated, even though they flow. They both. The first lawsuit is settled with the tolling agreement, and the second lawsuit is filed pursuant to the tolling agreement, your view is that they're totally unrelated?
They're all related because the first lawsuit, they counted claim.
Right.
That lawsuit. Okay, so now when there was a tolling agreement, they filed a lawsuit, they claim about.
That all happened in Montgomery County, right?
That's right, Your Honor.
And how is it that venue is improper in Montgomery at the later phases?
Because they're two different lawsuits.
Okay.
I believe so.
All right.
And they're filing against all the appellees, appellants residing in Prince George County. The suit should have been brought there instead of Montgomery County.
I understand.
Okay, Your Honor, thank you.
Thank you, counsel. Case is submitted. Thank you.
Media